Now that the Films and Publications Amendment Act is approved, cyberbullies and social media users who incite violence and hate speech over the internet will be fined or even face jail time. The new internet censorship law, which came into effect at the beginning of this month already, has been signed and proclaimed. Now, the new regulations state no online user may distribute distasteful messages. To tell us more about these new laws, I'm joined by Pandeli Gregoriou of the Film and Publication Board. He is the Manager of Legal and Regulatory Affairs. So he's the right person for us to speak to. So many questions being asked on the internet, of course. I'm sure you're aware, especially after that press conference that was held earlier today. I'd like to start just by the putting together of this act. Obviously, there was a commentary. This was open for public comment a couple of years ago. I think 2019 was when the whole process started already. Where do we stand in terms of international best practice? I know the EU has a proposed Digital Services Act, the UK has a proposed Online Safety Bill, and at the centre of all of that is what is called trying to prevent or regulate online harms. Was that the point of departure for the putting together of this act as well, the preventing of online harms?
So that's a very important question. So the context within which the Amendment Act was developed and ultimately signed off or assented to was on the premise that if we reflected on the legislation, you will see that the legislation is actually a 1996 Act, actually didn't consider the fact that we were actually going to be consuming content in very different ways. We were not going to be consuming content in the context of physically going into a theatre to watch a film, for example, or even in the context of back then buying a DVD and watching it at home. The fact that the dynamic space within which content is consumed, especially in terms of online platforms, required us to think of how we then amend the legislation to ensure that our legislative mandate is executed. And in essence, to be able to firstly inform the public in terms of what they're about to watch or consume, and importantly, enable them to make informed decisions for also children in their care. So it was to be able to try and cover those spaces as well. When you asked and you posed the question about where we stand as a country, you will see in terms of at least the research that we've done, you'll see that South Africa is actually quite a couple of steps ahead in terms of other jurisdictions, in terms of how we've developed the Act and obviously getting it off the ground. Others are still in the process of doing so. But we are breaking new ground, and we are going to be sort of seeing how that transpires in due course.
In what area are we breaking new ground?
So in the space of, and you actually mentioned it, in terms of the expanded mandate of the institution, we are abundantly aware of the fact that content is being distributed in many different ways and in very sort of different contexts. But beyond the fact that content is consumed in that space, we actually have to be quite sensitive to the fact that there is content, and social media platforms is one of them, where content actually may amount into one of the prohibited categories, right? So where content is, for example, contains hate speech and it's being distributed on social media, we need to be sensitive to the fact that there must be some sort of measures in place to be able to regulate that space. And what we would obviously do in that space, and obviously what the Amendment Act does, it creates certain prohibitions and offences if that were to occur. Obviously, there's a certain process that would have to follow if that were ever to arise, but that's what would happen in due course. Obviously, we'll unpack that and give it the relevant attention that it needs.
Let's try and simplify this conversation, because people will drown in the legalese involved, and we want to ensure that people understand what is involved here. So there's various reactions to this act being proclaimed that I want to cover. But let's first look at the classification of films and the websites upon which people often access films. Because, I mean, let's be honest, people are watching films on all kinds of websites that some friend or auntie or somebody who lives in China or in America sent them and said, yeah, you can get this latest film, just click on that, and if that one doesn't work, try this one, and there's this one, and change that. And people are just clicking on all of this, and the prevention of harm comes in that they could be clicking on things that will expose them from a cyber crime point of view, but also if they've got kids, they're waiting to watch the latest Disney movie, perhaps illegally so, could be exposed to porn that they weren't expecting to open up. Is that also part of what you're trying to communicate here?
So to be able to clarify, right? So the important premise is that in terms of the provisions in the Act itself, it does require any person who's going to be distributing content, and it expands that beyond the physical to also the online. If you're going to be distributing content, to firstly, and if it's film content, to register with the Film and Publication Board that you intend to do so, but ensure that each and every title that you are going to be distributing on those platforms has been classified. And by classified, you would notice it's a triangle. It's a triangle with age ratings and consumer advice below that, that it allows you as the consumer of that content to know what kind of age rating it has in terms of the age rating that it's going to be pitched at, and if there's anything in that content in particular that you need to be sensitive to. It allows you to make that choice, but also allows you, if you have children in your care, to make those informed choices for them as well. Now, when you speak about how do you access those platforms, even online platforms under the Amendment Act are required to be able to be registered by the Film and Publication Board, and they have an election. Either they submit the content to the FPB for classification purposes, or they can enter into a co-regulatory relationship with the Film and Publication Board according to certain specifications, where they take on the responsibility of self-classification, but nonetheless classify that content in line with our classification guidelines in the country. So that should then protect our consumers of content. The moment you know this is a platform that is duly registered and that the content is classified, you then have confidence in accessing titles that are available on that platform because it has fallen within our legislative scope.
There's been some reaction, some criticism maybe, to what a distributor is defined as according to this Act. I mean, there was a few conversations and threads on Twitter today saying that, or asking whether this means that the many tens of thousands of content creators we have in this country, does this mean that every time they make a reel or they make a video or a TikTok video, they need to send it off into the ether to somebody at the Film and Publication Board, wait for approval before they can publish it, because before they can post it, because that's going to be a lot of work to try and regulate, if that is the case. Is that the case?
It isn't. So the definition of a distributor that is captured in the legislation says that if you are a distributor if you have the intention of actually having a commercial transaction, right? If there's going to be some sort of commercial endeavor that is going to take place when you are then creating that content and ultimately distributing it, right? So in the context of the examples that you've given, the social media platforms, for example, where you're just posting pictures, films that you have created, if there's no commercial transactions, there's nobody who is transacting with you to access the picture or the film, then they don't fall within the legislative scope of the Film and Publication Board.
So if I think of
user-generated content is not a baby.
Okay, so if I think of famous influencers in South Africa, I think of people like Maps Maponyane, and the list goes on. If they post the video, and often they probably might be making money out of posting something, being paid by an organization to be an influencer for them, that too doesn't need to be approved first.
So there's an important distinction, right? So the moment you fall into that category, so the way we would assess a distributor of content, as I told you, there has to be some sort of commercial transaction. The moment you're an influencer, and we know that some influencers, for example, would have some sort of commercial transaction at play where they would say they maybe have a paid partnership with some sort of entity, and they are then using that platform in order to be able to then have that sort of product being displayed and advertised, then in that space, then you would fall within the legislative scope of the Film and Publication Board. It's actually quite a technical issue that we would need to consider, but it is something that would, in terms of the definition as is captured by the legislation, would mean you would fall within the legislative scope of the FPB.
How are you possibly going to police that and keep up with the massive amount of work that is going to entail?
Precisely. So I think the preliminary sort of engagements that the Film and Publication Board is anticipating is, as opposed to going to sort of those individual sources, is be able to look at the platform as a whole, right? So you look at the platform as a whole, and if you as the platform are intending to distribute content or allow content creators to distribute their content on your platform, which would fall within the legislative scope of the Film and Publication Board, we would want to then see how do we get into that engagement and that discussion to say, ultimately, we want to be able to protect our consumers of content, right? We want to be able to protect them and children in their care. So whatever is being placed on your platform, if it falls within our legislative scope, you are ensuring that they're not going to be exposed to something that they shouldn't be, right? So it's going to be looking at it holistically as opposed to trying to deal with it as a one-on-one kind of scenario.
Okay, and I do have to wrap it up, but I'm sure there'll be continued conversations about this. So, for instance, if somebody who is an influencer who makes their living off it, if they're posting something on a big platform like a YouTube or a Facebook or an Instagram, from what I've been reading, those platforms have agreements with the Film and Publications Board already. So that would kind of cover somebody already, wouldn't they?
Precisely. So the moment we have an online distribution agreement with a platform that has agreed to be able to ensure that content that is going to be on the platform is aligned to our classification guidelines, people who make use of that platform to be able to distribute or exhibit their content would fall under that specific agreement. So as long as that agreement is in place with the platform, then they would be covered. They would not have to worry about that because the actual platform itself would ensure that the content meets the expectations of the Film and Publication Board and would not expose the public or any child to any particular harm.
Okay, we're going to leave it there.
Which is the approach that we are proposing. Yeah, sorry.
Okay, we still needed to talk about gaming as well, but we'll leave that for another conversation. Thank you so much for your time and for your insight. That's Pandeli Gregoriou from the Film and Publications Board. He's the Manager of Legal and Regulation Affairs.